Case on our docket, it is Richard Diamond as trustee versus Terry Vickery. Before we take argument and start the clock, I have one preliminary question. We received a motion from Mr. Diamond indicating that the bankruptcy court had approved, transfer of this cause of action to another entity. We have not received a position from Mr. Vickery. My sense is we're probably bound by the bankruptcy court's order, but if Mr. Vickery has any dog in this hunt, let us know.
Very well, Your Honor. Do you want to address the 9 year or just after the?
No, if this isn't part of your argument, I'm going to take out of your time. I mean, does it matter to you if we change it's essentially, it's almost like somebody dies and you substitute in the administrator of the estate.
See, I'm not sure if we have any grounds to oppose that. I've been running like crazy the last week or so with this case, and then arbitration's coming the rest of this week in court in Wyoming as well. So I haven't really had a chance to look at that.
Well, would you like some additional? I don't see if there's any exigency. I mean, would you like a modest amount of additional time?
We could.
How much do you want?
I don't know, we could.
Okay, our current practice is to do this by written order rather than oral rulings because it's easier for the clerk's office to keep track of. So we will issue an order and probably won't get out till tomorrow, giving you a week to take a position on the motion.
Thank you.
Is that all right?
I'm not sure we have any grounds to oppose it that way.
Yeah, I'd be surprised, but I've been surprised before. All right, on that basis, we are ready for oral argument in Diamond as trustee versus Vickery. And at some point in your argument, counsel, and you can bring it up whenever you want, I would like your position on what the effect of our ruling will be on Mrs. Vickery, if any.
Yes, Your Honor. May it please the court, counsel. My name is Martin Byer. I am the attorney representing the Chapter 7 trustee. I'm not going to say specifically who I'm representing today since I have a motion pending, but it will either be Mr. Diamond as the Chapter 7 trustee or his assignee, the Dan & Gill firm. But with respect to the question that Judge Webb first raised, we don't believe that Mrs. Vickery has asserted any position here. I mean, she had an opportunity to respond to the Rule 70 motion. She did not do so, but we think it's somewhat irrelevant, primarily because of our position regarding the homestead exemption, that regardless of which Vickery person we are talking about, neither of them have standing under the statute. I was planning before going into that to just briefly take a minute to address the argument that was raised in the reply brief on the cross appeal regarding the assertion that the district court granted a broader remedy in its order, particularly in paragraph 10 of that order. First of all, I don't believe that argument was fully fleshed out in the opening brief, so that allows this court to disregard it, and I would encourage the court to do so. But to the extent it is considered, we don't believe that it's an accurate assertion of what the district court held. The broader remedy referenced in paragraph 10 of the district court's order, and I'm speaking specifically of Judge Reisman's order, was that Vickery's request to raise an equitable bar to prevent Mr. Diamond from all future collection efforts was denied. He had asserted latches and waiver and estoppel, and the court's analysis focuses exclusively on that. There was no additional remedy being afforded, and certainly there was no remedy granted to Mr. Vickery in that part of Judge Reisman's order, and so we would submit that this appeal is not moot. The only issue being whether Judge Reisman accurately decided that the homestead exemption applies. Our position is that on the merits it doesn't, and that's because there is a distinction that Judge Reisman did not appear to appreciate between record title and equitable title. He appeared to believe that there was an inconsistency in our position on arguing first that the legal title rested in the trust, and therefore it was not in either of the vicaries. But that, in fact, is just what the record says. It's what the deed, the recorded deed says. It's what's in the court. It's what's in the clerk and recorder's office. It's what all of the world believes as to title to this property, because that is what's of record. The second.
But didn't you argue, and ultimately successfully, that the transfer or series of transfers that got title to the property into the trust were fraudulent?
Yes, we did, Your Honor.
Okay, well, if those transfers were collectively fraudulent, doesn't that then mean that they're void and whatever prior title the owner had is reinstated?
Well, it could have meant that prior title was reinstated, but that isn't what Judge Munziker did in 2010. What he did is that instead of voiding the title, he imposed a constructive trust over the trust, the partnership, and both of the vicaries to assure that those assets were going to be available for Mr. Diamond to collect, to collect in his subsequent proceedings. So yes, we did in fact argue that it was a fraudulent conveyance, or there were a number of fraudulent conveyances. We're dealing with two levels of fraud in this case. The fraud in California, which resulted in proceeds that were then used here, commingled with property in various transactions involving the trust and the partnership, and there was then fraud involved in use and employment of those devices. And the court's order in 2010 was those were mere artifices. And so what you still had, though, was legal title held in a trust, because nothing ever changed that. And Judge Munziker did not say that because of the fraudulent conveyances, I'm going to, in essence, wipe away the deed. What he said was, I'm just going to impress this constructive trust. So he did do that. Now, Vickery then had no legal or equitable title interest in the sandstone property as a result of that. Our statute requires both a exemption, to assert the exemption, our statute requires two things: defeasible title and possession. Both of them must exist at the time to be able to use that exemption. We're not disputing the possession portion. They were in possession at the time of the second hearing. We are disputing, however, that they had any sort of defeasible title, because when a constructive trust is imposed, it leaves legal title where it is, but it takes equitable title and vests it in the constructive trustee. The constructive trustee was, at that point in time, Mr. Diamond. So even if there was some sort of beneficiary interest that existed at that time, it was an equitable interest that was, in essence, seized from the vicaries and transferred to Mr. Diamond at that time in 2010. So when we come to 2017, they are missing one of the two legs that they have to have in order to be able to assert the homestead exemption.
And counsel, this kind of goes not just to this, but to your alternate argument of waiver of the homestead exemption. When in the 2010 action could the vicaries have asserted the homestead exemption? Because they entered that, they defended the garnishment action by saying, we're not the record title, we don't own the property, the trust owns the property. So when would they have asserted their claim, their homestead exemption claim in that prior action? Would it have been in a post-trial motion? Would it have been as an alternate defense? Can you please address that?
It's a good question, Judge, and I believe they certainly could have asserted it, even taking the position that it was held by the trust. They could have, based on case law from other jurisdictions, have argued that they had a beneficial interest and could have asserted the exemption at that point in time. Certainly by the time we had this hearing, it was very clear that title to this property was at issue. If you look at the proposed findings of fact that both parties submitted, it was very clear that both sides thought the title was at issue. And when we're at the stage then, even after the judgment was entered in 2010, there's still absolutely no argument being made when there was an appeal to this court that they had an interest that needed to be addressed, that they could, at that point in time. It would have been too late, in my view, for them to have tried to assert the homestead exemption at that point in time, but naturally they would have done it, at this point in time, because this is when title was being decided. This is when the validity of that trust was being decided.
So when was their ownership extinguished then for purposes of making the homestead exemption claim?
It was extinguished at the time the constructive trust was imposed. At the time of the September 22nd, 2010 order, where a constructive trust was put in place because Judge Munziger found that there had been new fraud employed in taking this property in and out to conceal it as an asset of Mr. Vickery's from the bankruptcy court and basically from anybody else that was looking at title in the clerk and recorder's office. So he determined at that point in time that because of these fraudulent conveyances that he was not going to honor, not going to allow the trust as an artifice to be used against Mr. Vickery.
But what exactly was it that put Mrs. Vickery on notice? Because you just said Mr. Vickery, that put Mrs. Vickery on notice that she needed to act at that point.
Well, there's a number of things. First of all, Mrs. Vickery was a general partner, and she was part and parcel of the assertions. The partnership intervened prior to the 2010 hearing. Mrs. Vickery was certainly on notice then that what was going on, because the partnership itself argued that there was no right to take title to the property. There was an occupancy agreement that they were arguing that could not be set aside because of CUFTA, because they were arguing that there was no fraudulent conveyance, obviously. So she was certainly on notice. At that point in time, there was a Liz Pendens filed, I believe, though I think it came a day or two after the 2010 order came out. But there's just no doubt, though, that she knew that there was, in fact, action against her interest going on in that first case. And this court on appeal, when she was later held in contempt, ruled as much. This court held in that second appeal of the first order, which was a contempt proceeding against Mrs. Vickery, that she was represented in that proceeding. That in fact her interest was represented because she had argued there was no personal jurisdiction to put her in contempt by ordering that she provide an accounting. And when she didn't provide that accounting, Mr. Diamond went back to the court and got her held in contempt, and attorney's fees were awarded.
Were she and Mr. Vickery in joint title before the transfer into the trust?
With respect to
The house?
the house, I do not know the answer to that question.
Did the
I
partnership
apologize.
ever have record title to the house?
I do not believe so. I believe the evidence at the first hearing was that there was a transfer from Mrs. Vickery to the trust, and it was only the trust that held title. I could be wrong, but it's that my recollection that that's what the record showed. So with that being the case, then she lost whatever rights she may have had to assert the homestead exemption at the same time that Mr. Vickery did. Now, I see I only have about 3.5 minutes left. I'd like to reserve some time for rebuttal unless the court has any other questions. I'm just going to go ahead and do that. Thank you.
Thank you, Your Honor, and may it please the court. My name is John G. Nelson, Colorado Bar 19907, here on behalf of the appellee cross appellant, Mr. Terry Vickery. And I would like to, if I may, begin with some of the background issues that I think are important and also which the members of the panel questioned my colleague on. In this matter, Mr. Diamond sought an order vesting title to what has been called the sandstone home in himself. And Mr. Vickery opposed that motion on two grounds. First, he asserted that he was entitled to claim the homestead automatically created under Colorado statute. And that matter was argued out, and Judge Vriesman ruled in his favor on that issue.
Well, let's just stop there. Exactly what interest, legal or equitable, did Mr. Vickery have in the property when the 2016-2017 action was commenced?
Legal title was still held in the name of the trust. Mr. and Mrs. Vickery and their family were the beneficiaries of the trust, so they would have had an equitable title to the property that had not yet been extinguished because no action had been taken on that issue.
Well, why doesn't the imposition of the constructive trust essentially extinguish their beneficial interest?
And that's the next level of the analysis, Your Honor. And that is that in the briefing, and this appears to be what you're focused on as well, Mr. Diamond appears to have admitted that the homestead exemption cannot simply be extinguished at the same time this title is sought. Therefore, they attempt to break the extinction or extinguishment of the homestead up into two stages. First, they say that the homestead was extinguished and the title was extinguished in 2010, and then second, that the property was taken in 2017, by which time the homestead was long gone.
Well, you're saying the title was extinguished. I mean, Mr. Vickery wasn't in title as of 2010.
As of 2010, the property was in the name of the trust. And I noticed that one of the members of the panel asked about who was title in before the trust had it.
That was me.
Okay, and I don't believe that's set forth in Judge Vriesman's order or in Judge Munsinger's order from 2010. And also, I wasn't counsel in the case in 2010. But I have discussed the matter with both Mr. and Mrs. Vickery, and they have assured me on multiple occasions that prior to the property being transferred to the name of the trust, it was in the name of Mrs. Vickery and was purchased initially with funds that she had from, I believe, from her parents. So if the trust was simply invalidated because they didn't adhere to proper formalities and, they transferred properties in and out of the trust and, all the criteria that are set forth in statutes for determining whether the trust is valid. If that trust is extinguished, then, as I believe you noted, the ordinary result will be that the property goes back to whoever had title prior to that, which would have been Mrs. Vickery.
Well, that may or may not be a correct observation of law, but can it happen until there's a court order reinstating legal title, apparently, to Mrs. Vickery?
Can what happen?
Well,
I'm sorry.
Logically, I suppose, if the transfer of title into the trust is declared void, then you'd ask, okay, well then who has the title? But the 2010 order doesn't do that. So doesn't title remain in the trust, subject to the constructive, in the trust, subject to the constructive trust, rather than, unless the trial court were to say, I'm voiding the trust and I'm reinstating Mrs. Vickery's title?
Well, I think the effect of the judge's 2010 order was to void the trust. They ruled that it was void.
But the judge didn't say anything about then in whom title resides.
Yes, he didn't, and the order seems to have been have had some shortcomings in that nature. But in 2010, title was in the name of the trust, and the Vickerys, their family, were the beneficiaries, clearly had an equitable title. If in fact their rights to the property were extinguished at that point for some reason, be it because of this alleged fraud in the transfer or anything else, then that action, I would assert, would have then triggered their homestead rights and required that the homestead be, that the proceeds from the property be separated and the homestead paid at that point.
Why wouldn't that action also trigger their obligation to assert the exemption?
Well, at that point, as Judge Reisman noted, I think very cogently, the homestead doesn't become an issue until the property is actually being sold, and at which point there are proceeds to be segregated and for the homestead to be paid, and that didn't happen. It simply was not an issue. That was not raised for whatever reason, and then Mr. Diamond didn't assert that issue for over 7 years, I believe. So it's simply the party slept on their rights, and the issue slept along with them. But clearly, the homestead existed at that point, if not later, and when their ownership is terminated, then they're entitled to receive the benefit of that homestead.
But counsel, wasn't the whole garnishment proceeding dealing with who has, among other things, but we're just talking about the house, is who does this house belong to? Does it belong to the trust, or does it belong to the Vickeries, or does it belong to Mr. Diamond as the creditor, as the trustee? Doesn't that put the Vickeries on notice at that point that people are trying to attach their home? It's not a foreclosure proceeding that would trigger their need to assert or to claim the homestead exemption?
Well, the homestead is automatically created under state law, of course. Colorado
Right,
used to be
right,
a
but I'm just talking
declared
about
state.
to claim it, to say, hey, this property is exempted from this garnishment attachment because it's our home.
There was no garnishment asserted directly against the property. There was I believe, Rule 69 post-judgment discovery submitted to, or maybe, I guess I noticed a garnishment, submitted to the trust, among other people. They responded that there was no property being held owned by Mr. Vickery, and then that answer was traversed. But the point remains that at the time, I mean, in 2010, the question of the homestead was never raised, was never made an active issue.
But who would raise it? Wouldn't it be the Vickeries that would be the parties that raised it? As the claimants? I mean, why would Mr. Diamond raise it? He's trying to get the property to satisfy the judgment, so I'm not sure who has the burden of making that claim. As I read the statute, the property owner does.
Yes, well, under the statute, there is a very specific procedure that needs to be followed in order to levy and execute against real property. Basically, you get a judgment, you follow the procedure set forth. I believe it's either section or chapter 13-52 or 1356. An affidavit must be filed by the party seeking to levy, certifying that there's equity over and above the liens and the homestead, and then you sell it. And none of that was done here, and frankly, looking at the record, I'm flabbergasted to understand why. It seems that many issues were simply overlooked. In fact, that ties directly into one of the other issues we raised in our brief, which is that in the Baker v. Allen case, this court held basically that Colorado has a specific procedure for levying on real property. And when that procedure is not followed, not only is, the proceeds of the sale segregated to provide for the payment of the homestead, not only is that improper to not provide for payment of the homestead, but it's actually void as a matter of jurisdiction because the court has not followed the statutory required procedure, and has no authority to order otherwise. And
Judge Munsinger, though, he froze all the assets. He imposed a stay. I'm assuming that went through the appellate process. And then when the accounting wasn't done, because that was also ordered under the 2010 order, then we had the contempt proceeding. Could that levying process have even occurred until the court lifted the stay and unfroze the assets? And does our record say when that happened?
There was no subsequent order issued by Judge Munsinger on
Okay.
this after 2010. In fact, I believe he retired from the bench very shortly thereafterward. And then the appeal, I mean, Mr. Vickery was in bankruptcy at the time. The appeal was filed after the bankruptcy stay was lifted. And that was the point I came into the case, and it was, kind of rushed in and did what we could. Trying to raise issues that had not been, had not been waived. And then, as you know, Mrs. Vickery was charged, because she was ordered to provide an accounting. Apparently that wasn't done, at least not satisfactorily, and then she was charged with contempt. And there wasn't a proceeding against her, and then there was an issue as to whether the court had sufficient jurisdiction over her personally to require that she provide that accounting and to punish her for not doing it. And the court said yes, and of course they did. And the question of whether, her rights, they had personal jurisdiction over her to adjudicate her rights really wasn't, I don't think, properly an issue in her appeal, although her counsel did raise some argument into that effect.
So how do you respond to your colleague's argument that she was clearly on notice because there was a contempt action being brought against her with the idea that the property would be attached and taken somewhere? That clearly she had to be aware of that, even if that wasn't the direct issue in front of her on the contempt proceeding.
Well, she was not on notice. I mean, number one, she was not a party to that proceeding in Jeffco District Court. She did not have counsel. She was not aware that her rights were being adjudicated in any way. She was there, at least part of the hearing, as a representative to assist the counsel for the trust. But that was it, and that's what she's told me. So her rights were nothing ever was filed that would attack her rights, including her rights to a homestead. And for what it's worth, she has told me she did not understand that was what was at stake. And she's not had a chance to raise this in court because there was never any motion that brought her in as a party. There was never anything filed by a party that said Mrs. Vickery's rights in this property are invalid for any reason. She was just somehow sort of swept into the process. And the trust counsel, who was focused on different issues, didn't assert that or raise that as an issue and defend her. Then when the appeal rose, the question, I wasn't counsel for appeal. She had a alternate defense counsel through the state. But from reading the briefs, it appeared that the issue on the appeal was she properly sanctioned for contempt of court? One of the arguments that was raised was they didn't have personal jurisdiction over her, which I think was not a valid argument because they did have jurisdiction, at least to the extent of saying you can require an accounting. But I think it's clear that, number one, there's no court order adjudicating her rights in the property or requiring her to present anything. There's no motion that ever provided her notice of that, and she didn't. As a matter of fact, have that opportunity. She didn't intervene in the case. So I hope that answers the question.
Yeah. Let me come back to my question earlier then. Exactly what interest did Mr. Vickery have in the property as of the commencement of the 2016-2017 action that would be a predicate for his asserting a homestead exemption?
Yeah, to assert a homestead exemption, the party would have to have a legal or equitable title. At that point, due to the somewhat irregular procedure that had been followed previously, legal title was in the name of the trust. And we would assert that Mr. and Mrs. Vickery both still had a equitable title through as the beneficiaries of the trust.
But
And
wouldn't
further, I was that if in fact that equitable interest was terminated in 2010, then that was that decision in 2010 itself would have then implicated the homestead exemption, and they would still be required to honor it. In other words, Mr. Diamond can't break this into two steps and say, okay, in 2010, I will terminate, get their rights terminated by some court action, and then but not do so to have to pay the exemption. Then in
Well,
2017, I'll actually take the property.
Okay, well, let's assume you're correct and that the 2010 decision was erroneous to that extent. there was no appeal from the 2010 decision. That's almost 10 years ago. So how can Mr. Vickery assert a position now based on a purported flaw in the 2011 decision that was not raised at the time or on appeal?
Well, if there's a flaw in the 2010 decision, what the statutes require when a property is taken is that the foreclosing party, if you could call them that, pay the homestead nonetheless. They have to like, provide the affidavit certifying that there's sufficient equity to pay it, and then the proceeds have to be paid. It's not up to the homeowner to ensure that they follow the necessary procedure. Secondly, as a practical matter, there was no issue regarding this because, as Judge Reisman noted, nothing arose in 2010. There was no sale of the property in 2010. There was no attempt to evict the Vickeries or otherwise divest them of their possession. So we believe that whatever rights they possessed in 2010, which would include their homestead, continued to exist through 2017, would continue to exist through today as well.
Thank you.
I believe I'm probably out of time. But,
You are.
okay, thank you, Honor.
Thanks for letting me hobble up here again. I think the 2 points I want to make in response are that the proceedings before Judge Munziger were much broader than just a mere garnishment. We also had a motion for charging order, which was before Judge Munziger at that point in time, and we also had a claim for fraudulent conveyance, which the trust expressly acknowledged in its proposed findings of fact and argued should be denied. Because those were the issues, the district court had to deal with a number of issues, not just whether or not the garnishment or the traverse to the garnishment, testing the validity of the answer to the garnishment was accurate or not, had to determine whether the trust and partnership were valid, had to determine whether the Vickeries were alter egos of these entities. And in fact, Judge Munziger held that they were in fact alter egos of both of these entities.
Well, because your time's limited, let me try to cut
Certainly.
through this a little bit. Is it your position that even assuming Mr. Vickery could have asserted the homestead exemption in 2010 by virtue of his beneficial interest through the trust, when that beneficial interest was subjected to a constructive trust, he lost the right to assert the homestead exemption?
Yes, sir.
Okay. If he lost the right to assert the homestead exemption in 2010, wasn't it incumbent upon you or the court to provide some mechanism for paying the homestead exemption, as would be the case if there was a foreclosure or an attachment? In other words, I don't mean this sarcastically, it seems to me there's a little bit of trying to have it both ways there.
And I understand the possible confusion here, but I think the difference is between whether you have an exemption that is attached to the property and whether that exemption has actually been invoked. And I think that that involves two different steps, because it isn't so much that when a homestead exemption attaches to the property that payment has to be made immediately. That's not the case. It still later requires under the statute that the person that invokes it have in fact both elements of what is necessary to invoke it, which is the type of title that the law recognizes that can be defeased, as well as possession, which is why a renter could in fact assert a homestead exemption, because if the person who had title leased that property out, transferred possession over to somebody else, and the very next day somebody tried to foreclose on that property, it isn't the homeowner, the title holder of that property that can assert the homestead exemption. It is in fact the renter that can assert it, because
Okay,
they've
but
got
here's where
possession.
I'm still not following this. Because possession isn't an issue, so
Correct.
there's no point in talking about that. Okay, so your position is that whatever ground Vickery had to assert a homestead exemption was extinguished in 2010, correct?
Yes, sir.
Okay, but although, assuming you're right, there was no mechanism put in play at that time to pay the homestead exemption. So how can a proceeding effectively terminate the basis for asserting the homestead exemption, but not in that process provide a mechanism for paying whatever the homestead exemption is?
And I believe the answer to that is that the statute itself was not intended to promote any sort of fraud. And if you look at the Copler case, which the district court itself cited, there is language in there that indicates that if a property is used in fraud, not that it's acquired by virtue of fraudulent proceeds, but if it is used in fraud, it in fact is not entitled to the homestead exemption. So once it was determined, as a matter of fact, that that property was used in fraud, and as a result of that, the remedy was to impose a constructive trust over it, there was no right to a homestead exemption. It could not be asserted at that point in time because essentially from the get-go, the actual reason that the trust had title was itself fraudulent.
Thank you.
Thank you very
We
much.
appreciate the arguments of both counsel. This is a complex case. We will issue a written opinion in due course. Counsel in this case are excused because we have only this case on our docket. We will issue a written, the bailiff may announce a recess. And just to clarify, in terms of your request for 7 days to respond, that doesn't start running until we issue an order, which will be at the earliest tomorrow.
Very well, thank you, Your Honor.
All right. The court will be in recess, subject to call.